understand. So it's a little windy. I'd say if you talk louder than normal, you'll be all right.
All right, I don't have the windows down, but I'm in a Jeep, so it's just not a quiet car.
Right, I understand. I used to have a Wrangler. So,
That's
all
what
right,
it
King,
is.
King, you are there? Can you hear us?
I can hear you, and I'm
Okay.
not in a car. I'm not in a Jeep. I, I'm just sitting comfortably in my chair.
Right, right. Okay. Well, and Steve and I are doing the same. We're sitting here in our den slash his office tonight. So we're ready to talk indictments this evening. On a programming note, I will say we are back from our vacation. We had a fantastic trip in Portugal and Spain. And so I am now back and ready to rock and roll on the legal stuff. So, Jason, I see you there. So if you want to comment, wave at me. Um, or DM me and or both, and we can put you in the box to talk also. So, okay, Aaron, I see you also too. So if you got anything you want to contribute from agent's point of view, be sure and pipe up. Let me know. All right, guys. So we're going to talk principally tonight about Comey. We can talk about some other stuff if we want, but I suspect this will occupy the bulk of the evening. And hopefully, we're going to have some questions. We've got a few from people already on the tweets from earlier. So, first things first, people want to know um, is this case going to, is this going to be it? Are these going to be the only charges against James Comey? And just so the record's clear, Comey was indicted yesterday by the grand jury in the Eastern District of Virginia, which in the Alexandria Division, which is just outside of D.C., over in Virginia, and for two counts, one for making a false statement, allegedly to the Congress, the other for obstructing the Congress by making that same false statement. So, and people probably know there were charges presented to the grand jury that they passed on, and we're going to talk about that and explain how that works and why that's on the docket, etc. But let's just start with the bigger picture. You guys, Ship especially, what do you think? Go ahead, King. Go ahead.
Before correction, the obstruction case, the obstruction count charges him with obstruction for making false statements, plural, but only
Right.
one is defined in count one of the indictment.
Right. So
So we
presumably
don't.
it's a piggyback, but you're right, it might be more encompassing than that. Yeah. So ship addition.
Which raises an issue. Is it unconstitutionally vague? Because uh,
Doesn't specify which
it doesn't
statements.
specify what he did. Uh, I guess you in discovery they can list the statements, but I'll
Yeah.
ask you experts: does that suffice?
Unfortunately, the answer is going to be yes. But if I
Yeah.
say unfortunately, from the defense perspective, the answer would be yes. You might be able to get a bill of particulars on that, which is a device where the defense can demand from the judge that the government explain better, basically, the charges, pr- principally so as to avoid any kind of vagueness or ambiguity type problems with the indictment. Those are easy to file and hard to get a judge to grant. I have had a judge grant that request in at least one case. And sometimes you need it as the defense counsel because you can't figure out from what the indictment says. Ship, I saw your article today about sort of the way this indictment is laid out and the way it is not laid out, as we've seen these long speaking slash screaming indictments in cases from the federal courts recently in the last few years, especially against Trump himself. And this one is definitely not pled that way. So we're going to get to that too. But let me get to my first question, you guys, which is, do you think these are the only charges we're going to see against James Comey, these two counts?
Well, okay. So Comey is kind of a difficult um, problem in the sense that, you know, after May 12th, 2017, he was no longer FBI director. So that's 8 years ago.
Right.
So most of what Comey did as FBI director is far beyond any statute of limitations. So the only way you would add counts, and the only reason we got these two counts is because as a private citizen, he came back and testified before the Congress in September of 2020, and largely that was as a result of the four FISA's Inspector General report, which came out in December of 2019, and then when COVID hits in March of 2020, everything just kind of goes, on hold for several months, and nothing happens on this investigation or everything else for quite a while. So, had Comey not come back and testified, you wouldn't even have these counts. And so, absent a successful effort to put together some kind of long-running, overarching conspiracy to do something illegal that runs into the last 5 years that you could link Comey to, he could still be included in the conspiracy, even though wouldn't have participated in the conspiracy presumably in 8 years. He could still be indicted for his own involvement if you ever developed that.
Right. So to be more granular about that, we've talked about that in the past, that maybe you could construct some kind of conspiracy count under either 18 USC 371, or, which is problematic, has various problems with it, or 18 USC 241, 242, which also has problems. But in sort of conceptual terms, you could maybe make out those charges and you could rope Comey into those two. But
Let's say it's possible.
right.
It would not be legally impermissible if the facts supported it. But the facts supporting it is that's the Mount Sisyphus.
Right, that's where the rubber meets the road.
Correct.
So, in theory, could you do that? Yes. Do they have the facts to support it? I mean, that's unclear
And
at this
I,
point.
I didn't get a chance to look this up, but what's the statute of limitations under the Espionage Act?
Under the Espionage Act, it depends on which count you're going on, but there are some 10-year statutes there. Sections 793, I'm pretty sure, is 10 years. So yes, for mishandling of classified information type charges, then potentially there is a longer statute of limitations at play. There are problems also with the Espionage Act. As a defense lawyer, that I always thought was a section that the government waved around a lot but never actually wanted to pull the trigger on, because there's constitutional problems with that statute. That this is the statute they decided to use against Assange, and one of the reasons was because they had statute of limitations problems. So yeah, so that, King, you're correct. That could potentially be another avenue, mishandling
The
classified information.
the reason I raised that this theory applies not only to the Espionage Act, those parts of it that are not barred yet, uh, a- but also to an ongoing conspiracy to cover up an original crime. And the crime involves what Comey did with the uh, what was he, a law professor, friend of Comey, Richmond?
Richmond, yeah.
Yeah, I think a case can be made that Comey set up Richmond as an off the books leaker. Put
Yeah,
him.
Jason and I were talking about this earlier today. Jason points out he's kind of a on the books, off the books at the same time, right? I wasn't aware that he was somehow a special employee of the Bureau.
He was a special employee of the Bureau, answerable solely to Comey, who used him solely to leak sometimes classified information.
That seems like bootstrapping, doesn't it?
Yeah, yes.
Um, but
Uh,
okay, yeah.
but if the whole purpose of the conspiracy was to get otherwise classified material out the door through this otherwise private person by setting up a false employee relationship with the FBI, uh, you've got a criminal conspiracy that if Comey failed to, if he misled Congress as to what he had done, you've got a possible continuing conspiracy that is not barred by the statute of limitations. And if the information that was leaked what met the minimum standards of the 10-year part of the uh, Espionage Act, you've got a straight on Espionage Act violation, potentially, if the
Oh,
facts support it.
right. So okay. So we I think are all in agreement that there could in theory be more charges coming against Comey, but we don't know if there are if that's going to actually happen or not. Um and we've talked several times about how likely would that be, and it's a bit up in the air, and it really seriously depends on exactly what your facts are and on whether or not the government has the stomach to bring such charges, because they would be difficult for a number of different reasons, some legal, some factual, some more at what I call atmospheric things, like are they just going to have the guts to pull the trigger and do it? Now, they decided to have the guts to pull the trigger and do this, which is, of course, a topic of debate all over social media, whether this is appropriate or not to have charged Comey with these two counts. Forget about anything else. But Ship, I saw your commentary today on this question of a superseding indictment. That's why I wanted to start with. Do we think there are any more charges coming? Because there's chatter on social media about, well, this is just the first round, and there could be a superseding indictment that would add other things. And people have questions.
He was a special employee of the Bureau answerable solely to Comey, who used him solely to leak sometimes classified information.
That seems like bootstrapping, doesn't it?
Yeah, yes.
Um, but
Uh,
okay, yeah.
but if the whole purpose of the conspiracy was to get otherwise classified material out the door through this otherwise private person by setting up a false employee relationship with the FBI, uh, you've got a criminal conspiracy that if Comey failed to, if he misled Congress as to what he had done, you've got a possible continuing conspiracy that is not barred by the statute of limitations. And if the information that was leaked what met the minimum standards of the 10-year part of the uh, Espionage Act, you've got a straight on Espionage Act violation, potentially, if the
Oh,
facts support it.
right. So okay. So we I think are all in agreement that there could in theory be more charges coming against Comey, but we don't know if that's going to actually happen or not. Um and we've talked several times about how likely would that be, and it's a bit up in the air, and it really seriously depends on exactly what your facts are and on whether or not the government has the stomach to bring such charges, because they would be difficult for a number of different reasons, some legal, some factual, some more at what I call atmospheric things, like are they just going to have the guts to pull the trigger and do it? Now, they decided to have the guts to pull the trigger and do this, which is, of course, a topic of debate all over social media, whether this is appropriate or not to have charged Comey with these two counts. Forget about anything else. But Ship, I saw your commentary today on this question of a superseding indictment. That's why I wanted to start with. Do we think there are any more charges coming? Because there's chatter on social media about, well, this is just the first round, and there could be a superseding indictment that would add other things. And people have questions about, well, A, how does that work? And B, what does that do to the statute of limitations? So evidently, they wanted to bring these charges now because if they're based on Comey's testimony to the Congress in 2020, they only had until the end of the month to bring them before the statute of limitations was going to expire on false statements or other charges based on statements he made that day. So it's obvious, right, that they got these two charges put together to get ahead of the deadline for the statute of limitations. So, Ship, why are you thinking that there might, in fact, be a superseding indictment?
Well, that was mostly just considering what we've just discussed about as a possibility. That these could, if they do bring a broader conspiracy under 241, 242, or whatever, that would just be joined to this one, and these counts would have been timely and would be preserved. I don't know that we have any more counts like these coming because they're going to, from his time as FBI director, because those, as we've said, are going to be time barred.
Right. And presumably they mined the transcript of what he said that day before the Congress,
Right now,
looking for any start statements they thought they could
yeah.
charge, right?
Now let me raise this issue though, because I went back and forth last night, first reading it, and then got up this morning as I was writing my Substack article, and I kept scratching my head over this question. This is why I wrote that little tweet late last night that said, the gravamen of the offense is the false statement, not the truth. Okay, so
Right.
and the false statement is, as alleged, made in the congressional testimony. Now, leave aside for the second the complication that the false statement was, "I stand by my testimony from 3 years ago." It's like
Right.
without without necessarily verbalizing the statement from 3 years ago. To me, that's a little bit of an issue that's going to be interesting to see how the defense tries to make
Right.
use of that. But
I agree.
set that aside. What would stop?
Ugh, I hate it when this happens. Ship, you said what would stop and then it completely cut out. Can you hear him at all?
It cut out. Tell Ship to slow down.
Yeah.
Okay, so what would stop the government from
Right.
submitting? I'm just out in the middle of nowhere, Nevada right now, so you're gonna have to bear with me, and I might drop off. Um,
Okay.
what would stop the government from submitting 10 different factual scenarios that are all contrary to "I never authorized a leak"? In other words,
Well, I mean,
the one,
nothing, right?
yeah, the one leak that they have alluded to is
Ugh, frustrating. So, Ship, I'm going to cut you off here, even though I can't hear a word you're saying. I think nobody else can either. But the point that I think he's making, you guys, is there could be multiple scenarios that would be Comey that would show a contradiction to what Comey said, with what he said being that he'd never authorized the leaks. And that's paraphrasing it. And you can see, even from our discussion of this, that to bring this kind of a charge and convince a jury that the person has made a false statement is difficult. Prosecutors will say, oh, no, it's easy to prove. And I was arguing with a former prosecutor on Twitter last week about this, saying, oh, it's easy to prove that. And the reality is, no, it's not easy to prove a false statement in many cases because it depends on exactly what the person said. And a literal truth response to a question makes it not false. So, you
A,
have
a,
to interpret the words that the
a,
person is saying.
Leslie, a literal truth of a statement such as "I stand by my prior testimony."
Right.
Close quote.
Right. So that's
That
not false.
on
It
it,
can't
on its
be.
face, it's true.
Right, that can't be false, right? That's his assertion of an opinion as to his prior testimony. So the false statement is the earlier statements that he made in 2017 in response to questions that were raised by Senator Grassley. So then
which
you
are
have to
barred.
look, which
That
are,
crime is barred by statute of limitations.
yes. Now, the argument that Ship was alluding to this, the argument, if you're the government, is well, you ratified your earlier statements, right? In 2020, you ratified your earlier statement when Senator Cruz asked you basically, do you stand by that prior testimony? And Comey said yes. Okay, so can you use a ratified statement within the statute of limitations to charge the statement that's being ratified, which is outside of the statute of limitations?
I think you can,
I think you can technically too, but I don't know of any case on that.
but
I'm not aware of any case, but you're in uh, law student heaven here.
Exactly.
well,
Right. This is like, final exam for, criminal law land here. So, Steve, what were you going to say?
this whole was Cruz's question literally, do you stand by your prior
More
testimony?
or less. You testified before. Is that still what you think today? And Comey said yes. Okay. So, but again, we're paraphrasing, right? And when you're
He
trying to
didn't
prove
he,
this as a prosecutor, you can't paraphrase. You have to
he
prove that what was said is false.
he never said yes. He said I stand by my prior statement,
Right. Same
which
as
which
today. Same
which
testimony
literally
today.
is true.
Right.
You,
Exactly.
you've bumped into those kind of cases that
Yeah.
say that if your answer is literally true, even though maybe misleading
Right.
in the full context, you haven't committed a crime.
Right. It's not false if it's literally true, which makes sense as a theoretical question. So, right. So, Comey's defense lawyers and presumably the government are going to have to be researching this question of what does the case law say about can you charge this kind of ratification of an earlier statement? The case law probably says yes, you can, but King, you make an excellent point that okay, but the falsity is actually then not really within the statute of limitations when the the statement within the statute of limitations, the one in 2020, is not ratifying the earlier statement by repeating the earlier statement, but simply by affirming it. I stand by it.
Well, I think the question needs to be very crisp, and Ted Cruz is a lawyer and a smart lawyer, but I think ideally what you'd like is somebody saying, Mr. Comey, do you reaffirm under penalty of perjury
Oh,
the
yeah. All
truthfulness of
right.
your
Well,
prior testimony?
right.
And
Yeah.
short of that, you've got something that gets increasingly squishy.
Right. And complicated for the jury to follow. So that's always a problem. Okay. So, Jason, I see you there. I'm going to try to add you. But to do that, I have to kick Ship off again. So, King, can you drop off as a co-host for a second so I can let Jason in?
How do I do that?
Well, maybe we
do,
shouldn't attempt it.
do I just leave and
Yeah,
then rejoin?
yeah, yeah. No, don't do that. Ship signed out instead. So,
Mm.
yeah, okay. We'll get Ship back in a second. Jason, so I'm sending you an invitation to co-host. When you get that, say yes. Um, okay, so yeah, so you've got these problems. As a defense lawyer, you could make a lot of hay with this. Okay. On the other hand, I think people are able to understand the concept of you are ratifying what you said earlier. And the real question is what you said earlier the truth or not? But you have the additional problem if you're the prosecutor that you have to proceed to prove this false statement based on what was literally said. And Senator Grassley's question is what it is, and you have to deal with that, whether it's clean and precise or not. Jason, you wanted to chime in here?
Yeah, so I posted a transcript down below the reply on the spaces if people want to see
Oh, good.
a transcript of what was actually said.
In which hearing?
In the 2020
In
hearing.
2020. Okay.
Yeah. So so yes, he does say, Cruz asks the question and then makes a whole bunch of statements about what McCabe has said in other places and sort of puts it in the McCabe context, but Comey doesn't want to answer in the McCabe context, and he sort of resists that.
Right.
And he says, well, I'm not going to talk about what McCabe said about other things, but I stand by the testimony you summarized that I gave in May of 2017. And that was from earlier in the exchange when he basically he read the transcript of his exchange with Senator Grassley in 2017. Have you ever been an anonymous source in any news reports about matters relating to the Trump investigation or the Clinton investigation? And you responded under oath, never. Then after that, that's when he goes into the diversion about McCabe. And then Comey answers, I can only speak to my own testimony. I stand by that as you summarized it that I gave in May 2017. Then after that, Cruz says, so your testimony is you never authorized anyone to leak. And Mr. McCabe, if he says contrary, he's not telling the truth. Is that correct? And then Comey says, again, I'm not going to characterize Andy's testimony, but mine is the same today. So
Right.
that's the actual exchange, and it's in writing down below if people want to see it.
Right. So this is what you have to work with when you're the prosecutor, right? Is to say, well, this is what they were talking about. Okay, but what exactly are they talking about? Right? What does Grassley mean when he asks him, have you ever been the source? Does he mean directly? Does he mean indirectly? Right? Does he mean, did he actually talk to the reporters? And Comey's going to say, well, that was true. I didn't talk to the reporters.
Well, he did the full Grassley exchange, which again, Cruz doesn't go through the full exchange here, but the full
Right.
Grassley exchange from 2017 was extremely broad, and Comey's denial was absolutely definitive and unequivocal. He
Right.
said never, and Grassley asked it multiple ways. Have you ever authorized anyone else to be an anonymous source? He didn't use a loaded word like leaking, which people could interpret different ways.
Right.
Right? He used precise language about, have you ever been an anonymous source? Have you ever authorized anyone else to be an anonymous source? I mean, I can tell you, being a staffer at the time, what we were trying to get at was there had been a whole host of leaks, including leaks of classified information that seemed to be aimed at undermining the new administration. And some of them looked like they were, many of them looked like they were coming from inside government. So the question was, right, was he involved in any of those? And so the questions were drafted as broadly as possible. And he absolutely, definitively, and unequivocally denied that he'd ever done anything like that. There was a news story that I posted on X today from April 2017 that discloses, that discusses some very sensitive information about intercepts of, intelligence, that discusses what Russia may have had. And, Richmond is quoted in that New York Times article, and that's April of 2017, which is a month before this testimony to Grassley in May of 2017. All the points you guys make are absolutely valid about, like, well, if he was not telling the truth to Grassley in 2017, it sort of doesn't matter now because it's way past any statute of limitations unless it can be sort of bootstrapped into some broader conspiracy charge.
Right. Although I think we're all in agreement that technically it can be charged as they've charged it as a falsity in 2020. It's just the difficulty for the government is going to be explaining it to the jury in a way that they understand. And plus they'll have to convince the judge first that they can do the bootstrapping, but probably the law will support the government there. But even if you can do all of that, you run into the problem. And I always say this on Twitter, people don't believe me, but the truth is, juries don't like false statements cases because they think, well, I wouldn't want to be, put on trial for answers that I gave that are kind of mostly correct, but maybe are technically wrong somehow, right? The government often overplays its hand in these cases and tries to say, oh, it's just like the end of the world that this guy only partially answered the question correctly. right? The juries don't like them. Now, here you have somebody who is testifying on an important issue. He's a high-ranking government official, right? For a law enforcement agency, jury might be willing to give this guy a harder time than they do just Joe Blow, you know, I mean, Letitia James is the other example that comes to mind about, people lie on their mortgage applications all the time. And often they won't convict people who've done that because they don't want to be convicted of it. They know that they've fudged their answers on stuff. So you run into this psychological hurdle in false statements cases, which you don't in a lot of other federal charges, that the juries kind of just don't want it because they can see themselves sitting in the defendant's seat. Maybe they won't have that response when it's a former FBI director, however, we'll see. Um, but yeah,
Just, just
so go ahead, King.
yeah, just uh, following up on what Jason said. Back when I was practicing and questioning a witness on issues like this, where you start off, like Jason described, with a broad,
Mm-hmm.
cover the waterfront question, a yes or no, at calling for a yes or no answer. Did I do this ever? Uh, and you get an answer you think is a lie. You have, you don't stop. You have to continue and pin him down to leave him no out the back door in a later perjury prosecution by saying, "Well, I forgot that one."
Right.
Most of my answer was mostly right. I just forgot that one. It wasn't intentional. You give him the examples you have in your pocket. Did you do it then? Did you do it now? This time? That time? Et cetera.
Anytime
Yeah,
between these two dates, anytime
correct.
after this date. Right,
Right.
exactly.
And so you pin him down to the greatest extent possible. Leave him no wiggle room should it come up in a later trial. Here they did not do that because in Congress you can't. You don't have time.
Right,
Everybody's got 5 minutes.
right.
So it's not like doing a cross examination of a witness at a
No,
trial.
because it can't be. Now, and we're
No,
not faulting Senator Grassley. He did a good
no.
job questioning this. He asked the right questions. But it's one thing for the Congress to be asking questions and trying to get information. And it's another thing to try to prove in criminal court that the person lied, made a material false statement. So the other point is that the government is stuck with what they charged. So, and the court will hold the government's feet to the fire on things like this. The government can't say, oh, well, it's close enough. No, they have to prove what they alleged. And in the indictment, they alleged that the question was whether or not Comey had not, quote, authorized someone else at the FBI to be an anonymous source in news reports regarding the FBI's investigation concerning person one. And I think we're all in agreement that person one is Hillary. Jason, do you agree with that?
I mean, that's what people are speculating. I mean, I don't know. That seems to be sort of the consensus of the folks in public. But I would note, if you look at the transcript, I don't think that part of the exchange with Grassley about authorizing someone else at the FBI is in the September 2020 testimony.
No, it's in the 2017 testimony.
Right. And it's not reread, as we were talking about before. He only reads the first part of Grassley's 2017
Right.
question.
So they have to be using the way that has to be put together then is that they're using Comey's answer. The prosecutor's using Comey's answer that where he references his own testimony, that exchange with Cruz about, well, I don't know what Andy McCabe is talking about, but I stand by my testimony as I testified earlier, right? Although he does say to Senator Cruz, as you basically paraphrased it or
Yeah, he
encapsulated it.
says, I stand by the testimony you summarized that I gave in May of 2017.
Right. And see, this is how, when you're a defense lawyer, this is how you win these counts because it doesn't line up. They're not talking about the same thing. And you can't be lying if you're not talking about the same thing, right? And the juries agree with that because they don't want to be convicted either for basically the kind of messed up way that human beings talk to each other. Right? Like if you, most people don't have this experience, but as lawyers we do. If you read transcripts of people talking or of people testifying, almost no one even talks in complete sentences, because as human beings we stop halfway through the sentence when all the non-verbal, cues that we're getting from the other person communicate to us that they have understood the idea that we're trying to get across. And so the person stops talking, the other person starts talking. So there's all kinds of, you can call them technical or loophole kind of problems if you want, I guess. But the thing is, to put someone in jail for lying, the government has to prove that they lied. And that's often not easy to do when you're dealing with human conversation. So this count seems to be specifically directed at the one statement that's in the 2017 testimony, the one specific question from Senator Grassley. So, honing in on this point of the question that's quoted in the indictment has to do with someone at the FBI. Jason, do you think that Richmond is covered in that because of his status as a special employee of some kind?
Well, I don't know, but there's been some public reporting that he is the person referenced, not McCabe, as was assumed in Cruz's question, which of course adds a whole other layer of complication.
Right. So let me
And
ask you this. When Grassley asked that question, do you think that he knew Richmond existed and or that he was at the Bureau?
no, but again, Grassley's
Mm.
question wasn't in the context of McCabe or Richmond, or it was as I said, a really
He's trying to
broad question.
gather
Have
information.
you ever served as an anonymous source? And actually, I'll tell you one of the things we were trying to get at in terms of drafting the questions. We saw all this information that appeared to be. I mean, there was the Flynn Kislyak call,
Right.
right, that had been leaked. There was, there was all kinds of information in the public that had been released apparently from government sources. And one of the theories was that, well, the FBI director, if it's FBI information,
Right.
he may be able to authorize it, even if it is classified.
Right.
And so we were trying to determine from an
Well, did
oversight
that
perspective,
happen?
okay,
Right.
is
Yeah.
there a classified leak investigation that needs to be going on, or did you just declassify it and leak the information about Flynn Kislyak or whatever? So that's why if you look at the full Grassley exchange, which I don't have at my fingertips here, but if you look at the full Grassley exchange, he also says, have you ever, authorized the release of otherwise classified information? Right? He gets into that issue as well.
Right.
Um, but yeah, I mean, Richmond was a special government employee when we interviewed him in May of 2017, right after Comey was fired. He certainly acted as if he thought he was a special government employee. We didn't know that at the time because no one had said that publicly at the time. But, I had just called him up. I'd gotten his phone number and called him up and started asking him questions. And we had sent him a letter. Grassley, Feinstein, Senator Whitehouse, and Senator Graham had all sent a bipartisan letter with their 4 signatures asking him for copies of the memos that had been widely reported that he had received from Comey.
Right.
Um,
And you're right
and
that it wasn't like the media was reporting that he had a bureau link. It was like he was Comey's friend who was a professor.
right, and
Jason,
that's all we knew at the time.
J,
Uh,
J, Jason, let me ask you a question. When did Richmond first assert that he was Comey's lawyer?
I replied to Leslie earlier with a link to our memo of our interview of him. I don't recall the date of that off the top of my head, but it's in that memo. But it's in May of 2017. He said various things to us. He was sort of all over the place. One
Sounds
of the
like a
things he
professor.
said at one point was that he was Comey's lawyer, but he wouldn't tell us when he became Comey's lawyer. He told us that he thought that our request for the memos had been handled by the special counsel's office and the FBI folks that were assigned to the special counsel's office on his behalf. And it was really confusing. You can see it in the memo we write up of the interview because we're like, well, you're not a government employee, are you? Like, what do you don't work for the FBI. Why would we expect the FBI to answer on behalf of you for our request for these memos? But he was definitely acting. And then it all made sense later when I learned, oh, he was a special government employee that was tasked with doing, among other things, media outreach and narrative, and pushing, trying to make Comey look good in the press. Like that was part of his job. That was his official duty. Then it all made sense.
And he's assuming at that time maybe that you guys knew that, so he doesn't understand why you don't understand that the special counsel would be, that would all be handled there. I mean, it's just this amazing sort of, we're all talking past one another situation. Well, the prosecutors are going to have to grapple with this. Was he at the bureau or wasn't he? Because
Does, does he show up on a org chart, organization chart for the FBI? I wonder.
Well, no, an SGE is a temporary
Okay.
duty, and he wasn't even paid. He was an unpaid, as I understand, and I don't know this stuff firsthand. I just know this from reading accounts of what came out later from the House side when they were doing their interviews of various people close to Comey, including, I think, Dave Rubicki, his chief of staff at the time. Yeah, he was an unpaid, according to those reports, he was an unpaid special government employee, but he was an actual employee in terms of like he had a badge, he had a security clearance.
in terms of the legal status, he was,
Yeah.
yeah, right.
Yeah, but those
So
are temporary assignments, so they're not permanent. So I don't know exactly. I can't confirm like exactly what dates he started, what dates he ended.
mhm.
Except I know from as early as 2015 he was one. Obviously I don't know if he's still, since he reported to Comey and Comey had been fired. Was he one when I was talking to him after Comey was fired? I don't know. Was it ambiguous? I don't know.
I see Ship is requesting to talk. Before you give him that mic, I
Yes.
got a question. I got a question to toss to the group here. Could it be a defense that this dude Richmond was all a sham as far as his relationship to the FBI? Therefore, the answer that I didn't authorize anybody connected to the FBI
Right. That's
to.
why I'm focusing on this
Yeah.
language in the
It,
indictment, which is
it
at the FBI.
so it is it could it be a defense that this was all set up as a sham? He wasn't really at the FBI.
Well, I don't think that's a defense that would work very well, right? You created the sham and now you want to take advantage of it by saying, no, he wasn't at the Bureau, even though I was, holding him out as being at the Bureau.
We're
Well,
talking
there would
about
be all sorts of other legal problems if he weren't an
yeah,
authorized bureau
Yeah,
employee, because he
right.
was
right,
getting classified
exactly.
information
Right,
as if he were one. So,
right. Which was clearly the point, right? Because Jim wanted to be able to give him those memos and stuff without quote unquote breaking the rules.
I
well,
have
yeah, and
run
he was
in.
supposed to be working on the Going Dark initiative and other
Yeah.
special, quote unquote, special projects. So that,
Okay. That adds something to
Right.
some meat on that bone.
Right. So
I was, I,
even if the senator didn't know that about this guy and his status or not, I mean, he still asked, I think, the question in a way that's useful. Was anyone at the bureau authorized by Comey? So, they can either prove that he was at the bureau or he wasn't at the bureau.
well, he asks it both ways. He asks, did
Yep.
Comey himself,
But that's
right,
not
ever
what the
serve?
alleged false statement is.
Right. Well, right. So he either, I mean, whether Richmond was quote at the bureau or not, Comey either leaked to Richmond, who was not at the bureau, or he authorized Richmond, who was at the bureau, to leak to someone else. Like it's all the same thing.
But not for
It comes to the
purposes
same
of the
end.
charge, because they can only convict him if they can prove what they allege. And the question is, their assertion is that he lied when he denied that he authorized someone at the bureau. You see what I'm saying?
Yeah, I see what you're saying, but they also, right. So I guess they would have to supersede it with a different, if
Right,
they
they'd
had to
have
go
to
with the
charge it a
theory. Yeah,
different
yeah,
way. But
yeah.
then they've got count two, which, as King's pointed out, allows for supposedly multiple statements. Technically, it says statements plural. Tristan, I see you there. I've put you in as a speaker. Did you want to pipe up?
If I unmute, does it sound horrible? I'm at a football game.
No, you're fine.
I think this SGE status is really strong, and you see this in other instances. They are never paid, right? So Huma Abedin, like there are lots of examples of SGEs being brought on, but they, again, to Jason's point, they are given a badge, like they are an official employee with all the rights that come with that, and with all the responsibilities in this case, or the baggage of that. So, um, again, to that point, at the bureau, I think is a strong point there. The other thing I was just going to add earlier when we were talking about Cruz is, or Cruz's later questions in 2020, is that Comey doesn't just rely on Cruz's, he says, as you summarized it, but then he also says, mine is, I'm not going to characterize someone else's testimony, but mine is the same today, without that kind of narrowing that we're kind of talking about, whether he was simply relying on Cruz's summary or not.
Yeah, but I mean, that's implied, right? And you could imply it the other way, that he's again referring it back to as you summarized it, right?
Sure.
So,
I mean, again, the language that he says specifically is, so your testimony is you've never authorized anyone to leak, right? And again, I think that
yeah,
that is the most direct, and obviously that's what the indictment gets at, is that line anyway, right? So
except it doesn't, is my point, right? What it would have maybe been easier for the government if they had said a little more fulsomely in this situation exactly what statements of Comey's they think are lies. They didn't do that. They said that he falsely stated that he had not authorized someone else at the Bureau to be an anonymous source. But they're not quoting Comey there, they're quoting Grassley.
well, that's right. And then later by 2020, they're requoting. I mean, Cruz reads Grassley's
Right.
that quote, right, and then after that
Right. They're
reading of
quoting
it.
but only
Cruz,
part of it.
quoting Grassley in part, but not actually Comey's answer. So I don't think I would
Yeah,
have written this count this way, but okay. But they're stuck with it. Although they could, if they
That,
wanted to
that
clean this up, they
they
could.
they could definitely clean this up, and I think they will. Uh,
Well, I mean, this runs us into the next set of questions I have, which is, why is this indicted this way? And Ship, you're on a listener now. I sent you an invite to speak. Let me
It
send it
says
to you
co-host to
again.
me. It says he's a co-host.
Well, now it says he's
Oh no, it
a
says speaker.
listener.
It says
Yeah.
speaker.
Yeah, I sent it to him again. So, because this indictment is 2 counts only. The second one does not specify any statements in particular. It just says that that he allegedly obstructed the Congress by making false and misleading statements, plural, before the committee. So the government can allege that like that without saying exactly what they are, but they will then have to specify what the statements are to the defense before the trial starts so that the defense can defend properly if they can. But that doesn't mean that the public will find out before the trial what the statements are. So, but if they do some pretrial litigation on that, we might get some pleadings from the government that make it more clear to the public what the statements are. So we'll see about that. But this indictment
Well,
is not a
Leslie,
model of
I think
drafting.
the same is true of sort of which leak are we talking about anyway, in terms of what is the evidence that they have that what he said was false.
Right.
What leak are they going to claim that he authorized? A lot of commentary today was focused on the McCabe thing, understandably so, because that was the context of Cruz's question in 2020. But as we've discussed here, it could very well be either some leak through Richmond, whether it's the April 2017 New York Times article or any number of any other leaks, and we just don't know what the evidence is, so it's impossible to tell. So I thought a lot of the speculation that everybody's talking definitively and analyzing as if, oh well, it's the McCabe thing, and here's all the problems with that, like that's all. I mean, it's fine, it's what people do, it's speculation, but
But that's what it is. It's pure
right,
speculation because you
yeah.
cannot tell from the language of the
And the
indictment
government
itself.
doesn't have to say in the indictment
Right.
at this stage they don't have to say that.
Right. So, Ship, you want to address this point because I know you did both in your article and also in your commentary about the National Review editorial, right? About what the language of the indictment being different from the speaking indictments that we've seen.
Okay, can you hear me now?
Yeah, but talk loud.
Yeah, okay. Yeah. So that indictment, when I looked at it, it looked perfectly ordinary to me. I come from a historical practice where we didn't create speaking indictments. Our indictments were not 50 pages long unless you were some kind of complicated scheme to defraud, and you had to explain it because you had to explain the scheme. A false statement, the only purpose an indictment serves in federal court is it's a notice document, and it's to allow the defendant has to have enough information to plead double jeopardy, to be able to decide if this is something I've already been prosecuted for or not. It tells you the date it happened, where it happened, and what statute you violated, and it typically speaks in the language of the statute and not much more. So
Right.
it is going to be the fact here that the case law has consistently supported the proposition that the indictment combined with the discovery provides the specifics to inform the defendant of the nature and facts of the charge. And the fact that the public can't figure it out because they don't have the discovery is National Review
Not a
editors
relevant
irrelevant.
consideration.
Correct.
Right, right.
It's not written for you know public debate and public consumption. Although all of these legal beagles online who have been spoiled by going back as far as well, I mean I'm sure other prominent examples, but going back as far as Mueller, who basically
Right,
wrote indictments as if they were press releases. Um,
right.
so I don't think there's any problem. I mean, I said that, I've heard that the indictment was, amateurish and subject to dismissal. And I'm looking at it thinking, man, when were you guys in court last? Because I don't
Right.
see it. Now, I mean, as I laid out in my Substack article, as a practitioner, I read that and started anticipating. The first question is, who are going to be the witnesses, and
Right.
are those witnesses going to talk to you before they raise their hand in the
Right.
courtroom?
In court.
Then I
Yeah.
have serious doubts whether any of the obvious witnesses will cooperate.
Well,
They'll
they did not in Sussman's trial, and it's going to be some of the same dudes.
right.
So,
So then,
okay, Chip, it's so loud that I'm going to have to ask you to put your mute on. Thank you. Um, okay, so right, Chip and I are in agreement with this. The indictment on its face, I don't think is defective, but I think it shows inexperience the way that it's drafted with someone who hasn't had to try any of these cases. Um, because there would have
let me
been
ask you.
ways to
Hold on,
draft
Leslie.
it that would have made their life easier.
Do, do you think that the new U.S. attorney with no federal criminal experience wrote that indictment? I don't. I don't think she.
No, I don't think
Yeah,
she's the sole author
I
of
don't
it.
think she's the
No, I
author at
don't.
all. I think it came out of Maine
Yeah,
Justice.
Well,
maybe, but
can I jump in a minute?
yeah.
Uh, this may throw a different light on it as to who did it and with what due diligence. My friend Walker Fire
Mm,
just sent me a message
yep.
that there's that a document was drawn up and sent to the OGC for Richmond to sign to renew his status as um, being connected to the FBI. He never, he was never officially reappointed because he never signed it. This was in February 2000. He'd signed up originally in 2015. Uh, it came up for renewal or end of term or uh, in February 2017. They sent him a document to reaffirm his status, and he didn't sign it. Now,
Interesting.
what's that do?
Yeah, I think that's consistent with what I referred to in the House side deposition, and I think it came out in 2018, or it was taken in 2018. I don't know when it came out, but on the House side in the Judiciary Committee, Jordan interviewed Ribicki, the chief of staff, about this, and I think that's where the February 17 date comes from. The key question for me would be, well, okay, what happened then after he didn't sign the document? Did
Right.
he continue to have his badge and access and receive classified information from Comey and continue to act, in all the ways he was before, even though he hadn't signed it? And that could raise a whole host of other questions about the propriety of the arrangement, none of which might be relevant for the
Well,
criminal case. But
that gives Comey an easy defense. To my knowledge, he was no longer associated with the FBI at
Well, it
that point.
runs him into the problem that you identified, which is okay, but you were giving him the memos, which are classified in part, at least.
Yeah, so
And how are you doing that if he's not associated with the Bureau?
that's why it's a cleaner case if they can come up with that kind of a conspiracy or espionage act violation, I
Right,
think.
right. So to
Unfortunately,
Ship's point about, the drafting of it, I don't know if this new U.S. attorney, what is her name, Halligan? Um, whether she drafted it or not, I tend to think not. And maybe Ship's right that somebody at Justice did. But I'm just saying that as a practitioner of defending 1001 statements, lots of them, I don't think that that indictment is drafted in a way that makes the government's job very easy. A more experienced person who had dealt with the problems that 1001s can have for the government would have drafted this differently, I think. So I don't
But
know who did it, but they didn't do a good job from the government's point of view.
but put it another way, an experienced lawyer slash prosecutor drafting this indictment who knew about this February 2017 unsigned renewal document would have to address that in somewhere, somehow. You can't leave. You have to plead around it, or because it gives the defendant, as
Something
I
to
said,
work with. Right.
a
So if
massive
Jason is
hole.
right that that wasn't the only way that Grassley articulated the question, then why are you locking yourself into that one articulation, which is what they've done with this count? Right? If his questions were broad enough to encompass Richmond, whether he was a special employee or not, okay, you can charge that, but you didn't. You picked this one lane and now you're stuck with that lane. So, well, they could amend it between now and Tuesday, whenever the 30th is, but they'd have to go back to the grand jury again. So, speaking of that, let us turn to the issue of that they did go to the grand jury with a different charge, which the grand jury did not return on. So, if you look at the docket, there is the indictment, and then there is another document which is called report of a grand jury's failure to concur in an indictment. So this is a requirement under the rules of criminal procedure that if the grand jury declines a charge, then the government is supposed to make this report to the court and give the court a copy of what the grand jury declined to return an indictment on. So in this version of the indictment that the grand jury did not accept, the statement for count one, which is allegedly the false statement, is different from the one that we've been talking about. So it says, on or about the same date, September 30, 2020, so we're looking again at that testimony to the Congress, that Comey made a false statement, tracks the language of the statute, by falsely stating to a U.S. Senator during the Senate Judiciary Committee hearing that he did not remember, quote, being taught, end quote, of person one's approval of a plan, person two, and the 2016 U.S. presidential election, of a plan concerning person two and the 2016 U.S. presidential election. So this is why people, including me, think that person one is Hillary, because in general, the government doesn't give people numbers and then if there's a problem with the indictment, turn around and give the different people the same number. So it would make more sense that person one is consistent across this count that the grand jury approved and the count that they did not approve. And in the count that they did not approve, this approval of a plan concerning person two and the 2016 presidential election is, I think everyone agrees, talking about Hillary's plan to tie Trump to Russia and Putin as part of the Russia collusion hoax. So that would mean that person one is the one approving the plan, and that has to be Hillary. Person two, therefore, has to be Trump, right? Um, and in the count that the grand jury did approve, they're talking about person three. And the question is that Richmond or McCabe? But the,
Or Ribicki or
right,
James Baker or someone else.
right, exactly. So, but the false statement in the count that the grand jury approved is about person one. So person one is in both versions of the indictment. And I think it only makes sense if person one is Hillary. So this count didn't go over with the grand jury. And in fact, the count that the grand jury did approve of, according to people who've read the transcript of the hearing before the court unsealing the indictments, said that even with the count that they did approve, only 14 of the 23 grand jurors voted yes. Now, they only needed 12, but they didn't get the whole grand jury to go along even with the count that they did approve. So I think this count is weak. I'm not shocked that the grand jury rejected it, because to charge a false statements case um, where you're purposefully saying that the false statement is that the person doesn't remember being told something about someone else, that strikes me as crazy. What do you guys think of this count?
It's a no-brainer. You don't go with it if unless you have a pile of evidence
Right.
to show that
To the
that's
contrary. Yep.
yeah, right.
Yeah.
You can't use inferences to show that, because nobody's memory is perfect.
Right.
You got to have hard, strong evidence of conversations and documents. Basically showing that's something you cannot have forgotten.
Now, they imply that they could have proved that, because the next paragraph says that he said that he didn't remember, but in fact, he had been provided information concerning person one, Hillary's approval of the plan, concerning person two, the Trumpster, and the election. Okay, but even if you had proof that he'd been provided all of that documentation, that doesn't necessarily mean he's lying when he later on says he doesn't remember it.
Right. Well, it would depend on when he was provided the proof, right? I
Yeah,
mean, if
right.
you had his if you had his hearing prep materials, um, and they were very clear, that would be, if it was closer in time to when he's testifying, then it would be slightly stronger.
Right.
I personally would like to see a pile of evidence to show that he got the information and then did something, a huge amount of something with it. So the fact that he would act on it and make changes, do something,
Tell
you
other
know,
people to do something with it,
tell,
do
yeah,
tasking with it or something.
yeah,
Right.
it's hard to make a case that you forgot something that you went to all this trouble to deal with it.
Right. And what they're talking about is Brennan's memo across to the Bureau explaining that CIA had picked up information, and we won't go into how, because we're not going to go down that rabbit hole tonight, that the Russians thought Hillary had approved this plan to tie the Trumpster to the Russians. So, Brennan tells the Bureau this, hey, it's going to be coming your way that there's this plan to pull this dirty trick on the Republican candidate. And, FYI, it's coming down the line toward you. And Comey and Strzok, I think, are the only recipients of that documentation from Brennan. So I don't know, the indictment doesn't give us any indication of when did any of these things happen? When did he get the information? When was he taught about it? How long ago was that between when he, then and when he's testifying? So I, I'm kind of astonished at this. This is that would be a very difficult charge to prove. I guess it's borne out, isn't it? The grand jury wouldn't even buy it.
Don't we understand this? It's very imprecisely worded, no question,
Yeah.
that charge, right? But don't we understand this to be from other? I don't have this in front of me, and I can't pull it up right now. But based on other information that we have, that this was at the end of July 2016. It was the end of the month after Comey had already announced the closing of the Hillary Clinton case. And my recollection, and I'm trying to remember where we know this from, right? But is that he did take some specific actions based on it, um, which is why I would, if I'm remembering correctly about that, think that they had some confidence in. Oh, there's no way he could not remember that. Now that doesn't change. If someone says I don't remember, as opposed to just saying that didn't happen, those are different things. It is very weak to base something on. I don't remember. I just don't know how you can charge that. But in terms of the underlying facts, we know more about that, right?
Yeah, what struck me also is this quote of being taught, that he was taught this. Who is doing the teaching? Jason, do you have any context for this for us?
No, and I read that odd wording with the same quizzical uh, uh, view that is in your voice, right?
Right.
It doesn't make any sense. I don't know what that means. Again, I mean, I was speculating, pure speculation, right? That I mean, the only way I can imagine that you would be that I would feel confident, bringing, arguing something like that would be as if I had their hearing prep info, right?
Right.
Um, but
Leslie, to me, that sounds like it was written by a patent lawyer, describing the teachings one perceives
Right,
from
exactly.
from a patent.
Right. The way it's worded, it makes me think that in this version, they are quoting Comey. In the version that the grand jury accepted, they're quoting the question rather than the answer. Here, it looks like this is Comey talking.
well, I haven't gone back and searched the 2020 testimony for this part because I just wasn't as focused on the part that they didn't bring, or
Right.
didn't return a true bill on. So I don't know, but I mean, somebody could run a search on the
Right.
2020
That's what we
hearing and
need to
look.
do is read that
Yeah.
transcript and see who is speaking here. But context wise, it reads to me like it's Comey, not the senators. Um, so okay, the grand jury didn't like this, and probably for the reasons I articulated earlier, that juries don't like these cases. This is a good example of it. Really, you're going to indict some guy because he says he doesn't remember something? They would have had to have put on, King, as you say, like really good proof that's just straight up a dodge, right? You're saying you don't remember this thing that you spent weeks working on. Like, yeah, we don't believe that. But I don't think, based on what I know of the Crossfire Hurricane, I don't think there was going to be a mountain of evidence that would have, from which anyone would conclude there's no way Comey forgot about this memo that he got from Brennan.
Yeah. So following up on what
So
Tristan said earlier, I think he may have been referencing Tristan. I think you might have been referencing something slightly different. So there's the Clinton plan intelligence, as it's being referred to in the reporting, right? Which is what everyone thinks this is referring to, in exchange with, I think, Senator Graham about that, I think is what people think this is about. But Tristan, one thing that he did take action on, which he would absolutely remember, it would be really hard to believe he didn't remember, would be the information about the alleged Renteria emails, right? About Attorney General Lynch supposedly giving assurances that she was going to make sure that Comey didn't go too far in the Clinton email investigation, right? And that is referenced in the April 2017 New York Times article that I was referencing that I posted earlier today about that same article that quotes Daniel Richman approvingly, doing his defending Comey's honor thing. And that is the thing that Comey hung his hat on to justify his decision to come out and announce the resolution of the Clinton email case. So that, I don't know if that's what you're referring to, Tristan, but that is certainly something that he would definitely remember, because it's the excuse that his handpicked people gave to the New York Times for why he jumped out ahead of the Justice Department and took it on himself to announce that no reasonable prosecutor would prosecute Clinton. He said he was
So
motivated to do that because he was afraid if this information about Lynch came out that the Justice Department would lose credibility, and then only he, Mr. Comey, the great credible one, could ever, tell the country that there was no case there.
But that's
and
not the
wasn't it with
approval of a
Renteria
plan.
emails? I was just gonna say, wasn't it the same Renteria emails though that had the allegation that the Clinton camp cooked up the Russia hoax? Right? Isn't that the
Yeah,
same?
I think we might be conflating. I'm not exactly sure. We might be conflating two things here. They might come from the same sourcing or similar sourcing, but that I was just trying to reach for
What
something
else
that,
could it be? Right.
yeah, right.
Yeah, I don't think I think the two are separate because the the cooked up Russia collusion was associated with Hillary's someone who was Hillary's foreign policy advisor. I don't think Renteria had anything to do with that.
Right, but I think the point Tristan is making is it might come from the same cache of documents, and so therefore
No,
the
that's
argument
true.
would
That yeah,
be
they hacked.
he
Yeah,
would know about this because he took action based on the same cache of
the
documents.
Russians hacked the same cache of documents, as you said, and that's where they got it.
Well, I
So
have the
then,
trans. I was gonna say I have the transcript if you want to hear that part of the 2020 hearing.
yeah, I'm looking
It's
for it now, but if you've got it, go lay it
yeah.
on.
Josh Hawley says, if I could, Mr. Chairman, just one last thing I want to follow up on. The letter to Chairman Graham from John Ratliff, which I know you've seen, Mr. Comey, as you mentioned earlier. Mr. Ratliff says on 7th September 2016, U.S. intelligence officials forwarded an investigative referral to FBI Director James Comey regarding U.S. presidential candidate Hillary Clinton's approval of a plan concerning Donald Trump and Russian hackers as a means of distracting the public from her use of a private mail server. Did you open an investigation? Comey says, I don't know what that refers to. As I said earlier, I'd have to maybe go back earlier. That does not ring any bells with me when I read that. Holly says, you did not receive any investigative referral of this nature. Comey says, I don't remember it. Maybe this isn't the one. I looked last night and I remember reading it from the hearing transcript, and now
No,
I'm
this is
actually
what
not.
I remember too. He clearly testified in that hearing that he did not remember getting this missive from Brennan. And it
Right.
only went to him and Strzok because it only went to the Crossfire Hurricane team, right? And Strzok was the lead on that. So, the other people, members of the team, this is one of the things that it came out recently in the materials that were declassified by the Trump administration that, some of these guys who were working on the Crossfire Hurricane team were astonished to find out that the Bureau should have been aware that this was a dirty trick and that they were
Yeah.
not informed of that.
What is somewhat bizarre is the phrase being taught is
Yeah.
not in that hearing transcript.
And see, it's quoted in the charge.
Right.
So where
I'm
is that
going
coming
back and
from?
forth between the charge and the transcript, and it's very,
Yeah.
very unclear what the heck that is about.
Right.
What, uh,
The approval of a plan concerning,
Yeah.
just to
uh,
clarify
uh,
again, I think is, but not the being taught.
there is a being talked. Uh, it could be a misprint,
Yeah.
a
Could be
typo.
transcript error.
You look at what Lindsey Graham is saying.
Oh, You're right. You don't remember getting that or being, it says talk, but you're right, being taught. This is just an automatic transcript I'm reading. I'm sure if you view it, that's what he's saying. Being taught, that doesn't, Mr. Comey says, that doesn't ring any bells with me. That's right. This is the original one. This is Senator Graham earlier than the, I don't know if you want me to read that part, but it's the same thing. Graham outlines the
Yeah.
same chain of events. And then Comey says, that doesn't ring any bells with me.
The first hat tip to Walk of Fire. He caught that first and sent it to me, and I'm repeating what he said. So full credit.
Okay, so the transcript, either machine or human, is not picking up Graham's accent, is what's going on there. But also, it again shows that the charged language is not Comey's answer, but rather the question that he was being asked by the senator, which is not really the best way to structure that count.
Yeah, no question.
Because, the four of us have been talking about this for what? An hour now, and it's clear as fucking mud, right? What exactly is the false statement? Can you imagine trying to explain this to a jury? And this one at least wasn't a ratification from 2017 to 2020. I can see why they went after this one first on that basis, but it's a remembrance. I mean, this just weak. It's just weak. So,
But
okay,
but the typo or the mis reading of what Graham said makes it worse.
it does, right? Because that's not going to show up on anybody's transcript, that
Well,
word.
and it gives Comey an absolute defense. I didn't understand what he was talking about.
Right,
I thought he said something else.
right,
Here it says he said talk. That
right,
doesn't make any sense.
right.
Well, he would
Now,
have heard it, right? I mean,
yes, in
he
real
wouldn't be reading
time.
a transcript. He's just sitting there listening, right? So,
Right.
Yeah, no, you're talking about a defendant who and his lawyer who can point to that transcript we just looked at, and it says talk, not taught, and talk taught. What the hell are they talking about?
Right. Yeah.
you know,
Well, they're not going to have to worry
it,
about it because the grand jury didn't go for this.
yeah, but
So there's that.
that's something that's a gift to a defense
Oh yeah,
counsel.
you almost certainly can't get a conviction on that charge because to convict someone on a false statement, the jury has to be totally on board with the government that this person said these exact words and they were false, and the person knew they were false at the time that they came out of their mouth. And this mess in these two counts is far, far from what's necessary. Which is not to say that Comey wasn't lying his ass off in the hearing, one of them or both of them, right? Because he probably was, right? He knows he's given all of this information to numerous people to put out into the public sphere through the media, and yet he's sitting there telling these senators that he's not doing that, right? If you want to big picture it. But you can't big picture it for a false statements 1001 count and get a conviction because the law requires more than that. I mean, Jason, Tristan, do you guys think he lied? Just forget about could you prove it in court, but does it seem clear to you that, yeah, he lied?
Oh, okay. Are you kidding?
yeah, he did. He
Right,
did.
right,
Are you kidding?
right.
I mean, of
Yeah,
course I mean,
right.
look, can I prove it? No. Sitting there that day in 2017 behind Chuck Grassley when he said it, did I think he was lying? Absolutely.
Sure, of
I was
course you
sitting
would.
there, and it drove us crazy as oversight professionals because, I can tell you, for doing this for 25 years, we've been lied to so many times, like it's not even funny. Nobody's
Right.
ever held accountable for it. There's never been a Republican who's been even charged with lying to Congress ever. I mean, I'm sorry, a Democrat who's ever been even charged with lying to Congress ever. There's never been a Democrat charged with contempt of Congress ever, right? And so, from 25 years of experience, I can tell you they're always leaking stuff to the press constantly that they won't tell us as their oversight committee that actually has a constitutional, power of inquiry that they're supposed to be responsive to. And
Right, and they
so
think they can hide it from the Congress,
so when I'm
especially when
sitting
it's
there behind Chuck,
classified.
right, and
Yeah.
because and when I'm sitting there behind Chuck Grassley in May of 2017, and we've drafted those questions and he's answering them, I had read the April 2017 article where, clearly his friend, Professor Richmond, was working with the New York Times, and there's a whole bunch of stuff that appeared to be classified in that article,
Well, Jason, it's just
right?
magic. It's just magic how that
And it
gets in
just
there.
happens,
Right.
right? Like, I mean, come on.
Yeah, I know. This is ridiculous.
And not only
So,
that, but all the other articles that were full of classified that were beneficial to the folks who were, pushing this hysteria that was going on at the time and went
right.
on for another 2 years.
Now, if the government was going to try to prove up these lies, that's what they would do. They would bring in examples of where, okay, well, this is in the press. This is the article. This is your friend being interviewed in this article. This is your friend that you shared these memos with who's being interviewed and quoted in this article, right? And you would nail it down to the point where the jury would be like, well, yeah, duh, obviously he gave him the information.
Right, but to y'all's point at the beginning, that doesn't they don't have to do that in the indictment.
Right. Yeah, they don't. So, they have to prove up the facts that make out the count. Ship was talking earlier about online about what lawyers call 404B evidence, which is evidence of other crimes. So, in this kind of a case, it would be interesting to see, will the government try to put on more proof beyond just the specifics of what they think supports the count, but more proof to show that he did leak to other people or authorized other people, McCabe, Ribicki, whoever, James Baker, to give information to the press in order to prove that he did it this time too. And this kind of evidence is very tricky in the law because it's what defense lawyers call propensity evidence. So you prove that the person committed the crime this time because they've committed similar crimes in the past, which as human beings, people think, well, if you did it once, you probably did it again. But strictly as a matter of logic, just because you did it before does not mean that you did it this time. The government still has to prove you did it this time, not just that you're the kind of person who does this kind of thing. So, but they have this other maybe out where they could bring in these other additional examples because count two is talking about obstructing the Congress by making false statements plural. So maybe they think they're going to shoehorn these other aspects of the transcript into that count too. I noticed, Jason, can you comment on this? Tristan, too, if you want, that Senator Grassley has said recently on Twitter that, what you guys were investigating there was important. And, the questions about the leaks, that was basically, he's not saying it the same way lawyers would, but he's saying it was material to the investigation for purposes of oversight.
Yes. Oh, so right. So on the materiality question, absolutely, I think that's a really easy low bar, and I think that lawyers or practitioners in criminal space might, I think, improperly transfer their experience there to this context and think that I think the materiality in a congressional context is a much easier bar than in a criminal context
Right.
because
Or an investigation. I agree.
Yeah, I
yeah,
agree.
because in an investigation, a criminal investigation, you have to prove it's material to the specific elements of the crime that you're trying to prove up. It's much more specific thing. But the Congressional Oversight Authority is much, much broader and sort of much more, um, uh, ill-defined, I guess. I mean, there's lots of things that could be material to the congressional oversight function, and this is, I mean, whether the FBI director was, facilitating leaks to go after the president's clearly material
Yeah,
to
I think that would
Senator's
fall
function.
into the interest zone
Yeah,
of the Congress.
yeah.
Well, and to
So,
your point earlier about just the limited 5 minutes, you said I had a very limited amount of time to ask. These are the things I chose to ask, right?
right,
Just the limited amount of time almost proves the materiality in and of itself. This wasn't just some like random happenstance conversation.
right, exactly.
Right. We're not talking about a letter of, one letter among 1,000 that we sent that he answered, and we're not parsing that, right? This was the annual oversight hearing for the FBI director. It was at a time of extreme public, uproar and consternation and hysteria about these topics. So yeah, it's just, to me, it's just self-evidently material.
I think so too. I don't think they'll struggle with that element.
But
Um,
yeah, but just big picture materiality. If you're a defense lawyer, and that's your only out on one of these cases, you got a long road.
Yeah, that's a hard road to hoe because the jury's on, conversely on the other side, they don't like that defense. Unless the government is being overly um, picky, being a martinet over the issue, in which case then the juries will say, yeah, well, that's not really super material. You didn't really need to know that. Again, this is usually more on like forms, right? But here, I think it's the materiality is a relatively easy lift for the government. But some people have asked about the venue issues. So, this charge is brought in Virginia because Comey was testifying remotely because it's during the COVID um, from his home in Virginia. That's why the charge is brought in Virginia. And venue is a requirement of the Constitution in the criminal side of the court. On the civil, it's very different. But the Constitution says you have to be charged in the district where the crime took place, and that district has to have been determined before the offense took place, meaning the geographic boundaries of the districts have to be established, and you were either in one district or you weren't at the time of the offense. So sometimes more than one jurisdiction can have venue over overcharges because you traveled through more than one, or you used the mail or something and it went from one place to another, or something involved in a fraud scheme. And so it's not the case that only one district can have venue. Could be multiple ones, but in this case, I think DC and Virginia are the only options. King, what do you think of that?
I agree. Uh, it yeah, you can make a case that the crime happened in either place.
Right. So, but Florida is not on that list. And so it's just the law does not allow in the criminal context for cases to be transferred to a different venue over the defendant's objection. The government can't even ask for it. The defense can ask for a change of venue. Usually you see that when there's been a lot of trial publicity, pre-trial publicity, and or the person has another reason for saying they can't get a fair trial in that venue. But it is not like the criminal side where you can consolidate cases and move them to another venue just because it's more convenient for everyone else. That doesn't happen. So even if there's a superseding indictment or there's additional charges brought in Florida, I don't think this case is going anywhere outside of the EDVA. Um,
The talk about Florida, if somebody has an inside source at the DOJ and is hearing things like that, they're talking about another criminal case.
right, there might
Probably,
be another case. Yeah.
yeah, probably the overall overriding conspiracy beginning with the Russiagate hoax. I've seen the theory raised that there was a conspiracy uh, to basically take Trump out of office, beginning from the day he took office in 2017 and continuing all the way up until uh, 2020. Uh,
So would they
and
only need like what one overt act of that conspiracy to have
the,
occurred in Florida?
yeah, no, the crime has to happen. Some portion of the crime has to happen in Florida, uh, but the tricky part is that it has to be a conspiracy that was extended by overt acts past the running of the statute of limitations, so past 2022, uh, and that could include things related to the Durham investigation, hiding documents, destroying documents, lying to investigators, and what have you.
King, you
Uh,
said 2022, and I think you meant 2020.
uh, well, the Durham. didn't finish until 2022 or 3.
Yeah, but I'm saying you said for purposes of statute of limitations, it would have to run past 2022 and
Oh, well, yeah, past 2020.
20. Yeah,
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 but we know there were investigations and official proceedings going on as late as 2022, 2023.
right. But they'd have to be somewhere between today and 5 years before today.
Correct.
So, in order, but then you could go back further if it's a conspiracy case
Yeah.
properly put together. So, and that could happen in Florida, but it would not result in this false statements case being transferred to Florida. That's not going to happen. This case is going to rise and fall in Virginia. Just like Trump's case, well, one was in Florida and one was in DC. Those weren't consolidated. This is the reason why the law doesn't allow it in criminal cases. So, will that happen? I don't know. We'll see. Um, another reason that the case could fall is this question of vindictive or selective prosecution. So, you know, Comey's lawyers might file a motion to that effect. It's very hard to make out that defense. We talked about this the last time we got together, I think, that, you know, defense lawyers make that motion, but almost never win it. But, here you do have the statements from President Trump about, wanting there to be action on charges against Comey. So there's a little more to work with there than there normally is, but probably still not enough to satisfy the standard. So I don't expect that motion to be successful, but I would say it's a non-zero chance that the judge will say, well, this is vindictive. The courts don't like that argument. They acknowledge it, they accept it. They will apply it in extreme cases like you're prosecuting this guy because he's of a religion that you don't like, right? Or of a race that you don't like. That kind of thing can get you some dismissals. But that you're being targeted for political reasons doesn't usually work. King, what do you think?
I'm sorry, I missed all that. I got distracted.
I was saying I don't. The defense probably will raise a selective and vindictive prosecution motion, but unlikely to succeed.
No, I agree that in this case it will not.
Yeah. So
Let
the lefties can rail about that all they want to. That, oh my God, that's exactly what this is. But the test for it in court is so hard that it's virtually impossible to make that out. So we'll see. We'll get good briefing on that, I would suspect.
Well,
So
they might have an interest in fighting that motion, fighting that very hard just for the public.
yes, exactly, for the narrative. So
can I
go ahead, Tristan.
well, I want to tie this, I don't want to interrupt this part. I want to circle back whenever it makes sense to what I had raised. It wasn't the Renteria memos. I figured out what it was, and it's actually interesting, I think. But
Okay, well, let's
again, I
talk
don't want
about
to
that
interrupt
now
this.
before we get too far from it. So go ahead.
Okay, so it's the Durham Annex that was released this year, which of course Jason saw at the time that it came out in 20. Well, no, that's not true. You didn't see it in 2023. So I don't remember. I guess you had seen it, the initial thing, Jason, when you were there. But anyway, in the Durham Annex, it
No, I saw the
references.
Clinton annex when I was there. I left the Hill in 2018,
Yeah,
so
yeah,
I
I
saw the
remember.
annex to the Clinton report. I never saw the Durham annex until it was
So
publicly released.
from the Durham Annex, it says in the days and weeks following receipt of the sensitive intelligence, which again, one part of it was the Renteria memos, but the other part was this mishmash of NGO emails, but it included the one that talked about the campaign, the plan to frame Trump, basically. So it says in the Durham Annex, in the days and weeks following receipt of the sensitive intelligence, multiple high-ranking officials received reports and briefings conveying or summarizing this, yada yada. On August 3rd, 2016, during a meeting at the White House, Brennan briefed Obama, Biden, Clapper, Comey, and other officials regarding Russian interference efforts, as well as the intelligence received concerning the referenced plan by the Clinton campaign. So they had a meeting in the White House. Brennan's notes say we're getting additional insight into Russian activities that cite alleged approval by Hillary Clinton on 26 July of a proposed plan from one of her foreign policy advisors to vilify Donald Trump by stirring up a scandal claiming Russian interference by the Russian security services. It goes on to talk then about the September 7th investigative referral. And I think that's where, when Graham asks about this, he really kind of steps all over himself because he says in that 2020 hearing, you don't remember getting an investigatory lead. And it's just all, again, the that part of the indictment that wasn't returned is a poorly written, but frankly that part of the hearing is a total mess,
Right.
because he goes all over to say you don't remember, this Hillary Clinton's approval of a plan concerning Donald Trump. You don't remember getting that. Comey says that doesn't ring any bells to me. But again, Graham mostly keeps framing it in terms of the referral rather than,
Hmm.
and to be fair, this was 3 years before the Durham annex, but rather than what we now know, which is he had a freaking meeting about it at the White House with the president. There's no way he doesn't remember the plan, but Graham really focused on the later referral, which kind of
Right. Well,
undercuts
Graham
that.
probably didn't know that, but your point is, it's not just that he forgot. I
It's
mean,
not
we know now in hindsight, it's not just that he forgot getting some referral piece of paper. He also allegedly forgot, like, this conversation in the White House with the president and Brennan.
right. So the idea of being taught of a person, one, I mean, again, to fill in, he didn't remember being taught of Hillary Clinton's approval of a plan concerning person two, isn't just about that one memo that he and Strzok got. It's that he's in the Oval Office with the
Right.
president, where Brennan comes and says, Hillary Clinton approved a plan. We, or at least we obtained this information. We're trying to figure out if it's true or not. And to be fair, when you frame it that way, that does sound like a load of horse crap, right? There's no way he doesn't remember that. But Graham really
Right.
kind of,
That
bungled it.
what also bungles it is, I think Durham said he couldn't find anybody at the FBI who remembered receiving the referral.
Right. But again, that's a different matter and because Graham framed it in terms of the referral. But again, if he'd said he couldn't, there's still no question that of the people at the FBI who would remember there was a plan, Comey has to be at the top of that list when you sit in the White House and have that
Right, but we
discussion with
don't know
that
that
group of
Graham
people.
knew that when he was asking the question.
No, no,
That
no.
he was
Graham didn't at all. But I'm just saying, in
yeah.
terms of now, to the extent the prosecutors were looking at that and saying, well, again, Graham might have messed this up, but boy, Comey certainly knew. And he keeps saying,
But
that
Comey's
doesn't ring any
answer is
bells.
still false. Right. Yes.
Yeah.
And they could use that potentially, right? They don't have to prove that Graham knew it. They only have to prove that Comey knew he lied. But you can see from what a mishmash it is, how hard it is when you have to have the level of precision that the court is going to require for a criminal conviction.
Right. That third indictment, though, might, or I guess now the second count, just other obstruction of the committee.
Right.
Maybe that's a place they could try and shoehorn in, saying, "Look, it was an imprecise question, but clearly you knew what he was getting at, and you feigned ignorance."
Right. Yeah. But
And I will say, as an overarching principle here, I mean, in my view, this is not, this isn't a legal, point. This is just a sort of, if our system's going to work, it should work this way kind of a point. Whenever we got into this parsing with any witnesses in any of my time on Capitol Hill, my argument was always just cut the crap.
right.
Like, be can't, if you're an FBI agent, by the way, this is relevant. At the FBI, you have a duty of candor. You're not supposed to be quibbling with the question. Like, if you
Right.
know what we're talking about, you're supposed to pony up and
Right.
tell
You're
us
not
the truth.
supposed to be
You're
trying to
supposed to
be
be
too
honest.
cute by half. You're supposed to be answering
Right.
the goddamn question. So
Right. And I guarantee you, under Jim Comey's watch, there were FBI agents who were drummed out of the bureau
right.
for not being candid and forthcoming on a lot,
Right.
on less close calls than this.
Right. Things of less importance too. Right.
Much less.
Right.
Yeah.
Because it is unbelievable. If you're sitting in the White House getting this briefing from the CIA director that the Democratic nominee, we have intelligence that we got from one of our adversaries that the Democratic nominee is ginning up a fake scandal against the Republican nominee. It's not like that happens every day.
But to extend that thought, the Democratic candidate is drumming up a fake scandal. It's put in writing by hired British former spy in very vague language that sounds like it came from a spy. And then that document is given to the FBI, which takes it and runs with it and launches a massive investigation that lasts for years. And Comey insists that that document goes into the official assessment of whether Russia interfered with the election.
Right.
Uh,
So, I mean, if you look at it that way, really from the highest foot level, whatever altitude we want to come at, how is it that they thought that was going to work? Right? These guys, y- Brennan knows about Clinton's plan. Comey knows about Clinton's plan. He can say he doesn't remember, but none of us believe that, right? We think that he did know it.
well, it worked. It worked.
Yeah, but why?
It
Right?
worked.
Why does it work though? See what I'm
It
saying?
worked.
How did
It
they
worked
think?
through deceit and fraud.
Yeah, but how did they think they were going to get away with, oh, well, we were told about this, but then we decided to act like we didn't know about it? You see what I'm saying? It's like, who are you expecting to believe that after the fact? It'd be one thing if the FBI really was
because they were
conned.
100% convinced that Hillary was going to win. That's why. And Hillary's not going to complain about it.
Right.
That's their entire worldview. Is that everything they did makes 10 times more sense if you just remember that prior to the election, they were 100% sure that the new president was going to be Hillary Clinton.
Except it still doesn't really, because if you really thought she was going to win, then why do you care about any of this other stuff? They weren't going to prosecute Donald Trump if she won. Right?
Right. Well,
No,
that gets ginned up after he wins,
well,
right? I mean,
well,
that's when he becomes prime target number one.
the short answer is the FBI didn't do much with it until Trump won. That's when it came to the top of the list. That's when we they launched this massive investigation that turned into the special counsel investigation.
Right, because they want to get him out of office. So,
Correct.
yeah.
That's when it really raised its head and became something we've
Well,
never seen before.
and then at that point, they have to deny that they knew about it, right? Otherwise, you run smack into the question I'm raising, which is when they told you that this was a ginned up plan that was going to be coming your way, how come you didn't recognize it when it showed up? So,
Because we wanted to believe what they were
right,
selling, right? We
exactly.
wanted
Right,
we wanted to believe
right.
that Trump did all
At
this
that
stuff.
point,
We
that's
thought he
what
was a threat to democracy.
they have to
Yeah,
say that, right? Or Comey
yeah,
has to say what he did say, which is, well, I don't remember being told that.
right.
Right? He can't be faulted for doing Crossfire Hurricane, knowing it's a big steamy pile of crap if he doesn't remember that he was told, "Hey, look out, be on the lookout for the big steaming pile of crap that's coming your way." It's just so crazy. The whole thing, when you really think about it too much, is crazy.
Well, and it makes sense then why they tried to put this aside from like the strength of the case, right? But
Yeah.
especially if Trump is like, look at all this crap that happened to me, and they're like, again, anyone objectively who looks at it, you're like, yeah, that's really outrageous everything that
That
happened.
was
So
really
then for them
bad,
to
right?
that was really bad. So they're trying to put this at the top, like the FBI knew this. Comey later tried to hide it. Yada yada.
Yeah.
You can see how they got to the mindset of thinking, well, this is what we got to do. It's just such a
Yeah.
difficult thing
Yeah.
in
Well,
terms of
and
precision.
also, I mean, I think it's the incredible irony in hindsight of all of this with regard to Comey and sort of the Schadenfreude that you see in many circles about Comey. I mean, for me, he look at the standard that he applied to
Yes.
General Flynn.
To other people. To Martha
Right. Look at the
Stewart.
standard that he applied to General Flynn.
Right. Yeah.
I know that Comey was acting in bad faith
Yeah.
with regard to that whole thing
Yeah.
and his allies in government,
Right.
because I know that he told Senator Grassley and Senator Feinstein in private before he was fired that, oh, the agents didn't think he was intentionally deceptive in the interview. And so, yeah, we made our referral over to DOJ, but I don't think there's going to be any prosecution of him for that.
Right.
That's what he said before he got fired.
Right.
After he got fired, all of a sudden that case was the number one key linchpin to prove that there was an obstruction case against the president of the United States.
Right.
And he just did a 180 because he got fired.
Right.
And
Because his ego got bruised.
right. And he was perfectly happy when, the government bullied Flynn into pleading guilty to something that he had previously said he probably wouldn't even be charged with.
Right. Yeah, exactly. Well, so this leads me then to a different question than I was going down the road before, but we'll come back to my earlier question. The current question is, people on the left have been losing their minds saying, oh, this is the end of democracy, as everything seems to be these days. That Comey got charged because, they're just going after him because the president hates him and he's on the president's shit list. And, therefore, it's the, find me the man and I'll show you the crime problem. And I have been going round and round in my own mind with this today because, on the one hand, boy, I just am not wasting any tears crying for Jim Comey that he got charged. I just can't bring myself to be upset about that because he's he's horrible, right? All the things that he did are so bad that it's I hate to say this as a lawyer. It's almost like, well, you know what? He kind of deserves it, right? On the other hand, I think to myself, okay, but as lawyers, we of course are not supposed to think, well, this guy gets prosecuted because he's a bad person, right? That's not what I believe at all. But the problem is he's been so sanctimonious about everything, Comey. And he does this whole thing with he doesn't know what 86, the president means. I mean, that was absurd, right? So it's almost like he's asking for it. Um, Eh, But then, on the other hand, and there's a lot of hands in this argument, but on the other hand, with all the nonsense that they pulled on Trump, you know, I can't bring myself to agree with them that, well, you just went after this guy because you hated him. That's not what's happening. They act like none of that stuff that happened to Trump happened, and that he's just got this enemies list for no reason, right? None of that is true. So, as a lawyer, I don't like this. Well, he's committed some kind of crime. Let's just get him for whatever we can get him for. But I feel like that's not what's happening here. And King, I was interested in your view of, do we think it's appropriate that they have indicted Comey separate from whether they can make out these charges?
Uh, put the strength of the case aside.
Right.
Um, I can make a good case for bringing this, assuming you had a slam dunk or close to a slam dunk, but they don't. So I don't know how you avoid that problem.
Right.
Uh, the if he committed a crime and you can prove it straight up without any obvious defenses, you bring it. Even if you think he's done far worse,
Right.
it may give you leverage in the big case that you hope to bring. Uh,
I mean, one
but
of the
if you,
problems for me is that, as we've talked about many times, there aren't that many criminal code sections that apply to what they did. What they did is really bad. It really has undermined the republic. But that
but
doesn't mean,
there are a handful,
right?
and largely found in either in the obstruction
Yes,
statutes,
arena, right?
and they so if you can prove a conspiracy, if you got evidence of a ongoing conspiracy and evidence of overt acts extending within the past 5 years, uh, that's the bigger case. And I would not, if as a practicing attorney with this in my plate, I would not do anything to mess that case up. I'm afraid this might do it.
Yeah, I hadn't even thought of that. But I just think, okay, they're not going after him because he's just, the president doesn't like him. That's not what's happening. On the other hand, this case, many people on the right were like, this is what this guy's charged with after all the shit that he actually did. This is all you can do, is these seemingly weak false statements cases. But the answer to that, as we've said many times, is yeah, because the bad things that they did were abuse of their power, but we don't have very many criminal statutes that apply to what they did because, thank God, we haven't needed them up until now, right? So it just doesn't fit into the normal criminal code context. So I don't know. I go back and forth.
I'm pretty strong on that. Like it to me, it comes down to whether you have a bigger case to bring
Mm,
with more evidence. If you've got that, I think this weakens it.
well, they were obviously afraid not to charge these and
Yeah.
lose the ability to on the statute of limitations. And I'm not at all convinced that they're going to bring a conspiracy case. I'm not convinced of that at all because I think it is very difficult. Right? What Comey and Brennan did here is, I mean, it's almost even hard to describe how bad it is. We don't have a crime that fits it. That's how bad it is, right? Because the crimes that we have that are on the level of how bad it is, sedition, treason, those crimes don't fit this scenario.
Maybe that could be true, but I before I conclude it, I want to see all the evidence. And my worry is by bringing in a new person to make the final decision, by having this split within the office that wasn't cleaned up beforehand, uh, it you're bringing on its face a weak case that could screw up a stronger, bigger case.
Well, I don't know how it would do that, but I'd have to think about that some more. You know, it's not a slam dunk that they get a conviction in this case, for sure, right? I could see a jury acquitting on it.
I don't. I'm not sure they can get a conviction,
Right.
frankly.
And
I could
Virginia,
see a jury acquitting on it, or at least a hung jury if
yeah,
no matter what the evidence is. I mean, we're all saying this assuming that there isn't, I mean, we don't know what the evidence is, right? They haven't had to show their
Right.
hand yet.
yeah,
If they do have a lot of evidence that proves that, yeah, no, he actually knew he was lying when he said that,
right.
and
Well, because we're all
they,
convinced that he is lying, so it
right.
might just be a
And
question of,
maybe they have the evidence to prove it.
yeah,
We don't know whether they do or not. So we don't really know whether it's a thin case. It's just a thin indictment, but that's
yeah,
how, as you guys have said, that's how indictments are supposed to be, really.
yeah,
These speaking indictments they were really for political purposes and were inappropriate. And, we made objections to several of the ones from Mueller because we had information that gave more context to
right,
what was implied, but it was just for the media narrative. That's what they were doing,
right,
right? And
yeah,
that was an abuse all of its own of the criminal process.
yep,
But Leslie,
Um,
to your point, I think this case, even if we feel like again, without knowing what evidence they have, this has the potential still to be more cut and dry than, say, would a conspiracy
oh
charge. And
yeah,
I'm
oh
with
for
you that I don't
sure,
think that's,
yeah,
and the political ramifications are lower. If you say, look, lying to Congress is straightforward. Everybody knows that's not allowed, right? And
right,
so it's just politically less dangerous, I would say, right? And again, more clear cut. Just if they had the evidence. Now, again, they could have drafted it better, and there's a lot of things
yeah.
that could have been better executed. But conceptually, I can see why one might gravitate this way.
Right, I can see so as well. And I'm not faulting for our side of the aisle here saying, well, there's got to be some accountability from these idiots, right, for what they did, because what they did is really bad. The left can deny that all they want. They're just wrong about that. This was really, really, really problematic. And galling for them to just act like, well, of course we did that because Trump is such an existential threat to the nation that we all had to lose our minds, don't you understand, and do all these things that are otherwise totally off the plan, but we did them anyway. So I understand why the right feels like, look, these guys have got to, something bad has to happen to them because of what they did. But it does go against this normal principle that lawyers believe in, that we don't prosecute people because they're bad people. We prosecute people because they've committed offenses. And we don't make up offenses like they did with Trump because he's a bad guy and we're just pretending that, oh, this is the crime of the century, when in fact it's not a crime at all. So, well, I mean, that ship has sailed. They've decided to indict him. I think it's without a doubt, he's not going to plead guilty. So there will be a trial. The EDVA moves relatively fast, so it won't be 2 years from now. It'll be sometime in the next 6, 8 months, 10 months at the outset, I would think. And we'll see. Now, I wanted to make this point tonight for everyone who's listening. There was a lot of chatter on social media today about the judge. And some idiot who can't read, apparently, was tweeting out that the judge had been hired by Comey in 1995 and then again in 2002. Did you guys see these tweets?
Yes.
Yeah, I saw the debunking of them
Oh
too.
my God. So, people, that is 100% completely false. This judge has never worked for the DOJ, not one day. In 1995, he clerked for a judge in this same court, Judge Brinkema, who has senior status now. And in 2002, he was hired into the public defender's office. So the person who is putting this out initially, I think, is just a troll and or too stupid to realize that all those offices sit within the Eastern District of Virginia because that's the federal district that they're in. So they all have that in their names. But they're three different things. The court and the public defender's office and the prosecutor's office are all different entities. So there is no conflict for this judge to sit on this case.
I'll say one other thing. If he clerked for Judge Brinkema, he knows precisely how to expeditiously handle a docket.
Right, he does. And he was a magistrate before he was appointed by Biden onto the regular court. So, my knowledge of him is that he's a very nice person, right? He's a polite, congenial judge. He is polite to the advocates, right? Um, that as a public defender, that he probably leans more toward holding the government's feet to the fire in cases than maybe some judges might.
Yeah.
Um, and but anybody who's been in the public defense or even private criminal defense bar is usually very good at applying the rules of due process and making the government prove its case, but also has seen and heard it all, right? And isn't too impressed by defenses that don't have anything to them. So,
My comment about Judge Brinkema, she is the author of the Rocket Docket
right,
in that district, which drives lawyers crazy, but keeps cases moving fast.
fast.
And she does not put up with any delaying tactics,
Mm-hmm.
any
Right,
subterfuge by trial lawyers. She knows all the tricks and gets to the heart of stuff. I suspect this guy has learned a lot of lessons from that.
right. Well, you don't get to be the federal public defender in a district and not have any wits about you. So, those people, men and women, they're good advocates for their clients. So they'll do what they need to do to defend people, but you become jaded in a way being a defense lawyer, right? Because you see all the excuses that people have for their behavior. So I expect this judge to be fair, and we'll see how he does on rulings. He was appointed by President Biden, so he's presumably on the left. Of course, most defense lawyers are. So there's that. Now, the defense lawyer that Comey has hired is a former prosecutor. What do you guys know about him, Patrick Fitzgerald?
I
Well,
don't
he's
know.
got a long history.
Yeah,
Yeah,
He's
he
got a long
does.
history.
Yeah.
I've read about him, but that's all I know.
Didn't he prosecute Scooter Libby?
Yes, he was the
Yes.
special counsel in that case. He and Comey have known each other, I mean, a long time, I think.
Yes, and Comey gave him copies of his memos to Trump as well, for
Right.
which the OIG criticized him
Yeah,
because
and
of
that's one of the
violation of
questions
FBI policy.
we have from the peeps is that a basis for throwing him off the case? Now, it's not easy to throw the defense lawyer off a case, but a judge will do that if they think that there's a conflict. But in general, in that scenario, it would only come up if the government says they might want to call the lawyer as a witness. So we could see those kind of motions. Maybe the government will try to throw him off.
Well, the leaking of it's not clear that the leaking of the memos is, among the leaks that they will try to use to prove that he lied when denying that he ever authorized the leak. So if it
Well, in
is,
fact,
then that raises that issue, right? That he's a
Yeah,
potential witness. If it's not among the leaks that the government's going to raise, then it wouldn't.
right. I
Well,
agree.
if the leaking of the memos would be the worst possible thing, because again, that was done after the testimony to Grassley. So I just feel like that would fall apart so quickly, because you'd say at the time he made the statement in 2017 on May 2nd or May 3rd, he had not leaked those particular
That hadn't
memos.
even
So
happened yet.
True,
So
because that
right.
hadn't happened yet. But then, then you'd have the question of, well, but he reaffirmed it in, in 2020. But you have that temporal ambiguity.
right.
Yeah, you and I have talked about that. I think that's very weak to say, well, what you said, when you doubled down on what you said in 2017 wasn't true later by 2020, right? That's just, yeah, there's that big ambiguity there. So
Well, jury's gonna love that. Yeah.
yeah,
So I don't expect Fitz Patrick. No, Patrick Fitzgerald. I always get that mixed up. I don't expect him to get thrown off, but I suppose it's not a 0% chance. He was a very aggressive prosecutor. So famously, he prosecuted, and I never pronounced this name correctly either.
Rod
Blagojevich.
Blagojevich,
Right.
yeah.
Yeah. He was talking on social media today about this. Right. And
Blagojevich was.
yes, and talking about
I need
again.
to I need to go find those tweets.
Yeah. Right. Talking again about, basically how he got railroaded by this guy. Right. So it'll be interesting to see the dynamic um, of the defense. How aggressive are they going to be? So some people seem surprised that former prosecutors become defense lawyers, but basically all of them do because they come out of the office to make money and they go to one of the firms, right? Or they retire from the office and go to a firm. Now, Fitzgerald, it his bio seems to indicate that he retired from Skadden in 2023, which I was a little puzzled by that because he's not so old that he probably hit their mandatory retirement age. I think he's only 60. So I wonder if there's something more to that than just he's just simply retired. But I don't know. I'm just speculating. But I would expect a lot of firepower from them in terms of motions and things. So we may have a lot of pleadings to discuss as we go along.
Well, I think there's also I think there's an irony from some people's point of view about him being a defense attorney on this after his prosecution of Scooter Libby too, which a lot of people
Right.
famously thought was a thin case as well.
Right. Yeah. Um, so,
Although he was successful.
right. Yeah. Okay. So we've got some questions about can we comment on whether this case is intended to be like a speaking trial, like Sussman and Danchenko's cases were, right? Which was seemed more like an exercise in illuminating the situation rather than they're trying to actually put those guys in jail. Um, what do we think? This has a different feel to me than that. What do you guys think?
I agree with you as it stands now, but I can see that second count, the obstruction, uh, being superseded by um, to bring in something broader uh, that ties to what his testimony was in that hearing. Um, they might try that to substitute for the big case I've been talking about if they don't think they can bring that or
Yeah.
prove it.
Right. This may be all they've got. Their only shot. So they're going to shoot their wad. So we'll see. People are wanting to know why do we think that the Trump people didn't bring this case against Comey in the first administration, or why didn't Durham, deal with it in his time? Why?
Because nobody, especially the professional class in Washington D.C. and the professional career lawyers in the Justice Department, who frankly, would need to do the bulk of the work, not
Work.
political
Yeah.
appointees,
Yeah.
right? Those people just don't care about people lying to Congress. They don't care about, and especially they don't care about people lying to Congress if those people happen to be Democrats or Democrat aligned. So
But
that's why I think they didn't do anything about it. You had
I, I, I think additionally, talking about the leaks and the underlying conspiracy to use the Clinton conceived hoax, so to speak, to go after Trump. A lot of the evidence for those did not get fully developed before John Durham came onto the scene. Everybody, it was all kind of clammed up. Nobody was talking. We didn't have documents until I think Ratcliffe in 2020 finally released some stuff. But by then it was too late. Trump was massively under siege with the impeachments. He could not have successfully prosecuted this back then that late in his first term.
Yeah, that's probably true.
Well, and the other thing is by the time the later, I guess the later Durham report doesn't matter, but all of these leak investigations, like the Arctic haze and Tropic, shoot, I forgot what the other one is, but those some of those stretched into the Biden administration
Yeah.
again in terms of their findings. And so it's one thing again for the professional FBI class to go in and say, well, we're not sure one way or the other. Now you have a very different FBI director and others
Yeah.
searching through all the documents, right?
Right.
And of course, one of the reports out there is that they did bring in Richmond and re-interviewed him recently. So again, if they
Yeah.
found even a tidbit of emails or something, again with a more eager eye for, okay, is there, we want to, if there's evidence, we want to find it, as opposed to just like, meh, that's work, right? And
Yeah.
it's,
Right.
as they said in the IRS case, big cases make big problems. But so to look that way and then bring in Richmond and confront him with other stuff could potentially really have enhanced the potential case.
Right.
Yeah, you don't find what you don't look for.
Right.
And yeah, it was Ray's FBI looking.
Right. I think we know the answer to that. So people want to know, is Comey on the lam? Because there was this dumbass reporting yesterday and this morning saying that somehow he was going to turn himself in today, which that's not how it works in the EDVA. So what will happen is that he will show up for the arraignment. The court issued a summons for him to do so. And at the end of that hearing, he will go downstairs with his lawyer to the marshal's service and they will process him there. And that's how that will happen. And that's pretty standard in the EDVA when you have either a plea that you're doing or an agreed arraignment date for nonviolent offenses. So the FBI is not going to go out and get him. Nobody's expecting that, at least of all the judge. And so, yeah, he's not, they did not even issue an arrest warrant, which the government has to ask the court to issue. Instead, they issued a summons. The docket shows that there was a return on the summons. So don't be misled by that either. That means that they served the summons on him. And in this case, they served it on his lawyer who agreed to accept it. So that doesn't mean that Comey came to the courthouse and appeared. It means he got the paperwork via his lawyer. So he is not on the lam, as some people have asked. Other people want to know, well, why hasn't Brennan been charged yet? What do you guys have to say about that?
To me, that goes back to that issue of, again, a broader conspiracy charge that I think is very difficult, in my view, right? It's just a very, having a meeting of the minds on all these things, right? Again, clearly from a political standpoint, you look at it, you say this is horrible, but in terms of a planned out conspiracy or something else, is much harder to do. And there are some different Brennan. I'd have to go back, and I haven't thought about that for a minute. Some different statements he's made,
Mm-hmm.
but again, at least they're not. I don't know if they're within the statute of limitations or not. So again, it's just a different thing altogether from all the stuff we've been talking about.
Right.
There are several Brennan lies to Congress that are outside the statute limitations.
Right.
Yeah. What's within the statute? Does anybody remember when he interviewed gave an interview to Durham?
I don't.
I don't remember when that was. He definitely did. They told him that he was a witness, not a subject or a target.
I think it was in two.
I mean, it was after 2020, right?
Yeah, it was. I think it was in 2021. maybe 2022.
So that's
Uh,
still within the window.
yes.
Didn't one of the senators make a referral to the DOJ? I think I tweeted about this, analyzed it at the time. And the problem is that what he said wasn't actually untrue. Right? This is so crazy because Brennan, I think, is a lot smarter than Comey. And, he has a habit of saying things that can't be legally construed as false, even though you can't believe a word that he's saying at the same time.
Well, there's New York Times reporting just from 2 days ago, inquiry into ex-CIA chief stalls after purged by Gabbard, right? So in July, Ratcliffe issued a criminal referral of Brennan, accusing him of lying to Congress just this year.
Right.
But
That's what I'm talking about. I
So
yeah,
analyzed that. There's no there.
a quick Google search shows that he was interviewed by Durham for 8 hours on August 21st, 2020. So we're past that statute too.
Yeah. Yeah. It's the Ratcliffe thing, Tristan, that I was talking about. I forgot that's who it was and how recent that was.
yeah.
There's no, again, for technical reasons, he's what he's saying, I think, is accurate, even though it's, maybe misleading.
There's a different thing that I don't think, again, I was at a homecoming football game for my kids earlier, so I might have missed this, but did you all talk about the Arctic haze, just how that ties in, if that is the basis for this, the
Yeah,
Arctic haze?
not yet. So
Okay,
we've got one more question
sure.
here from a peep, and then we can turn to that. The last question that I think we haven't addressed yet is, will he testify at his trial? What do you guys think?
Yeah. I don't know. I'm not a criminal attorney,
Right.
but he
Uh,
He
seemed
already
very
posted
eager
an
in his video
Instagram.
talking about it.
Yeah, he
Yeah, what he
does.
posted.
Yeah.
He already posted on Instagram saying he's innocent.
Right.
yeah,
I mean, I don't know what he could say that would be helpful.
I'm not sure he can help himself.
Yeah. Right.
Right now, what I know, if I were his lawyer, I'd tell him, sit down, and keep your mouth shut.
Right. And especially this kind of client, he's going to want to quote unquote defend himself, right? Like he's going to want to be his own lawyer, which never works. Um, so he will definitely, I think, make things worse if he testifies. So we'll see what he does. Okay, Tristan, you want to explain what you're talking about with the Arctic haze? Because I bet a bunch of people don't know.
Yeah, and I'm trying to pull this up to contextualize it, but so within the last couple months, this
Catherine
was released.
Heritage was talking about this earlier.
Yeah, she's been talking about it for a while, and even like Jake Tapper had highlighted that his sources were saying the Arctic haze leak investigation was the basis for some of this. So going back though, it was just the news. John Solomon that released this. He's had kind of a pipeline of documents
Yeah.
from the FBI, and it's a 69-page document, and of course it starts in August of 2017, identifying 4 articles from April and May of 2017. This is in the FBI's Washington field office, and they all have to do with the Hillary Clinton investigation. And so after a lot of that page count is made up of just of those articles themselves. But after that August, then you see in September of 2017 how they've officially opened it, and the real meat is in a final a memo, and they call it an EC, right? Electronic communication, that is from 2021. Where's the thing here? So anyway, this has in here like November or September 9th, 2021, the case closing. And again, given what we know, and again, both what we know in terms of person one being likely Hillary Clinton, as well as then again just the further leaks apparently, or maybe from whatever source, the Arctic haze. This was the source of it, but this is what gets into. I mean, it has these fascinating statements in here, like a whole section that starts with Comey, Richmond, and their interactions with the media, where it says, FBI, the investigation revealed Comey hired Richmond so Comey could discuss sensitive matters. Comey also used Richmond as a liaison to the media. On several occasions, Richmond spoke with the media without consultation with FBI or DOJ's Office of Public Affairs, which, I will say that in and of itself doesn't necessarily mean it's a leak. You could say it's authorized, but that certainly is helpful in making that case that that would constitute a leak. And then it goes on to say Richmond contacted journalists to correct stories critical of Comey, the FBI, and to shape future press coverage. Richmond did this both when he was an SGE, going back to earlier conversation, and after he resigned from the FBI. But to the extent that, again, implies that when Comey says on May 3rd, 2017, no, the question is, have you ever used someone else at the FBI to leak information to the press? Just that line alone, that phrase alone, seems to undermine that. And then this document is just kind of goes back and forth. It's kind of a seesaw. There's a lot of redactions. One after a big redacted section, it says, although Richmond later told interviewing agents Comey never asked him to talk to the media. And then again, you've got a whole redacted paragraph, which obviously is framed as though they found some other evidence otherwise. So again, there's just a lot of meat in there, and then it just ends up the final conclusion, as I scroll down here, is the investigation has not yielded sufficient evidence to criminally charge any person, including Comey or Richmond, with making false statements or with the substantive offenses under investigation. But going back to what Jason and I were kicking around, that again, if you're not really looking, or this is by that time the Biden administration, but the fact that they brought in Richmond again to question him, I think is really interesting. So again, this to me is the document that seems really fascinating to mine. I wonder if we'll ever learn what's further under the redactions,
Mm.
but it seems like this is kind of the roadmap that someone would have started with on the indictments we're seeing.
Yeah, so I replied to this space with a link to the Just the News posting of that document and a highlighted screenshot from one key part.
Catherine Heritage was talking about this as being maybe the basis for more counts for the superseding indictment. And I don't see it that way. This, to me, would be instances, it gives examples of where he maybe did authorize people to do it, or people were doing so on his behalf. And therefore, it's proving up the lie, is what lawyers would say, right? So you're saying he lied to the senators about this. Here's all the times when this did happen, which is the proof that he lied when he denied it. And so that, to me, that's not like more counts. That's just like more evidence of what the truth of the situation is contrasted with the lie that you're saying that he told. So it might help them on count two, especially where they're saying, well, multiple false statements were made to the committee. So to answer your question, Tristan, I don't know if the U.S. Attorney's Office was on top of this particular information or not. But it could easily feature, as at least in the fact pattern at the trial. And, why wouldn't they have been aware of it? It's only recently been declassified for the public to see, but, Maine Justice got to know about it.
Well, and it's been to be clear, right? This was shared from the FBI at a time when
Right.
they're preparing this other thing, right? Like they're laying the breadcrumb, the trail that leads to where this was going to go. So again, of all the things they could have released, it seems like there was a very deliberate decision as to why to release this to Just the News now.
Right. I agree. And so I appreciate Catherine. She's often right about things. And she certainly could be right that there may be a superseding indictment, but I don't see this trove of documents, this Arctic haze, I don't see it as being like a new pot of information that would generate new counts. I don't think that's right.
Right, right. I think this is again, what I had understood both Catherine and again Jake Tapper to be reporting was
Mm.
the body of information in this was where they picked up from and said, okay, this is what we're going to investigate further, and
Yeah,
this became the basis for the existing counts.
right. So, we'll see what they do decide to put on as evidence, but we're not going to get much preview of that anytime soon. Now, if the defense does file a bill of particulars, the government normally answers that in writing on the docket. So if they say, well, identify specifically what the false statements are, give us a numbered list. If the judge is agreeable to that, the government usually just does that in a pleading. It's not like they send it privately to the defense. So we might get a good look at what they're thinking the false statements are. More difficult for the public to see this 404B evidence, other crimes evidence. But in this scenario, and this is really, I think, what Ship was talking about in his article today. In this scenario, the other instances of when Comey maybe did this, the government would have a better argument than they often do that that's not propensity evidence, that it's examples proving up the lie rather than examples of when he committed the same offense previously. You guys follow what I'm
Right. If they
saying?
can,
Yes, yes,
yes,
yes.
if they can, right. If they can go with the, he adopted his broad categorical denial to Grassley and restated it, and that's what you're proving up is a lie, then yeah, anytime he ever authorized a leak to anyone is arguably relevant then.
Right. And direct evidence, not just evidence of other crimes, but direct evidence of the charged offense.
Right.
Yes, exactly.
Yeah. So I'll be interested to see how do they go about doing that. Well, we've been going for quite a long while here, you guys. I appreciate you both coming in tonight and helping us with this. And your firsthand observations clearly, improve the dialogue. So I appreciate that.
Okay.
King, have you got any questions or anything else you want to raise before we sign off?
No, that's all I've got.
Okay. All right. Well, I'm sorry we couldn't have Ship on for very long, but kid stuff is kid stuff. It's got to be his top priority. So that makes sense. Tristan, did you ever make it to your game?
Yeah, yeah, I was there to begin with, but I came home at halftime with the younger kids, so now
Uh-huh.
I had a computer in front of me.
Yeah, okay. All right, guys. Any final words before we sign off?
Thank you for doing this.
Oh, you're more than welcome.
Yeah, no, I think it's helpful for people to learn.
Right, to try and
Well,
understand, because it's,
I've learned stuff from Jason and Tristan tonight. This has been good.
yeah. So, all right. Thanks again, guys. I'm sure we'll be talking about this case a lot as we go along. So we will
Yep, happy to join again.
yeah,
Thanks.
reconvene later. Thanks, guys. Good night.
Bye.